We again weigh in on the legal back and forth that has hounded the impeachment of Vice President Sara Duterte. And joining us tonight is UP College of Law Assistant Professor Paolo Tamase. Good evening to you, Prof. And there's nothing that will interrupt our conversation tonight. Well, the House panel has said that, well, they want to see the silver lining in that at least summons were sent to the Vice President to answer. But on the other hand, there is no complaint because it was remanded to them. How do we figure this out?
Thanks. So good evening to everyone. If the lack of clarity of where we are really comes from the initial premise where what the Senate did is unconstitutional. There is no basis in the Constitution for this. There is no basis in the Senate's own rules and past practices for it. And so it already happened. We're in this space where we're trying to navigate the possible next steps for all of the parties. Now, on the part, I think, of the House, right, that silver lining is really based on, I think, the promise that there was summons issued today, and therefore we're expecting an answer from the Vice President in 10 days. That also means that there will be a response from the House 5 days from their receipt of that answer. But that's as far as what we know now, right? The rules, unfortunately, aren't very clear.
Do the House is seeking clarification for this remand, but the Senate wants an attestation from them. So should they give that or seek clarification first before responding?
So I think that legally, right, the House prosecutors are under the jurisdiction of the Senate in the sense that they're the ones who are presenting the case. And therefore, if we're trying to apply analogously rules of how we lawyers appear in courts, they have a duty to help the court achieve the ultimate purpose, which is to find the truth in the allegations that are being brought before it.
So is it your position that do you share the position of Senate President Chis Escudero that they are not co-equal branches in this particular case, but they are the impeachment court, and so they can order the House?
Yeah, that has to be contested, I think, and challenged. It might be true that the Senate would have some ability to order the House panel to comply, right? The lawyers representing the House to comply. But impeachment does not change the fundamental structural relationship between the Senate and the House. We call the Senate often the upper house and the House of Representatives the lower house. Constitutionally, they're equal, right? They have the same prerogatives. They don't interfere in each other's processes. And I think that was what was disturbing with the order that came out today, with formalizing the approval of the motion last night. If you look at the second page of that order, where the Senate discusses the order that it gave to the House, it orders not the panel of prosecutors to produce a resolution. It orders the House itself, and not just the House, but the House that has not yet even convened, to issue a resolution confirming its willingness. And that really, it's a very fine legal point, but it sort of already intervenes with the inner workings of the next Congress as to how they want to express their continued interest. So there's a problem with that, and I don't think the impeachment court or the Senate assuming its special role and constitutional role as an impeachment court would necessarily mean that it suddenly is now superior to the House, right? Even in this impeachment context.
Attorney Tamase, how is that different, no, from a crossover, right? So let's assume natuloy yung original plan and then today binasa na yung articles, yung presentation ng House prosecutor panels. But, next month in July, wala na, iba na rin yung Congress eh. How is that a different case in terms of continuity? And as opposed to now na pinapa-attest nilang 20th Congress na hindi pa nga nagyayari. Where we're assuming the 20th Congress will continue it, hindi pa rin naman sila nako-convene.
Right. There's a legal difference and there's a practical difference. Right? I'll go with the legal difference first. The first is that the Constitution provides for a very clear structure of how impeachment is done. We do it at the House level first, and then we do it at the Senate. There is no suggestion in the text of the Constitution, in the practice of the Senate here, in the practice of the Senate in the US, about this idea of one House returning a complaint to another side, right? That messes up our understanding of where we are exactly in the impeachment stage. Are we still trying to investigate principally or preliminarily the Vice President for these impeachable acts, or are we already looking for or assessing the evidence in a way that would result in a possible acquittal or conviction? Right? So it messes up the procedure, and that procedure is very important in a highly politically charged context like impeachment, because it's one of the assurances to the public that this process is undergoing, strict constitutional observance. So there's a legal reason for it. There's also a practical reason for it. It sets a very bad precedent for the future in how a Senate that may find it politically inconvenient, for example, to decisively rule that we should continue with impeachment, it will just pass on that question back to the House. And then the House will be forced to pass the question back to the Senate. So we already had a 4-month delay from February, another 2 weeks in June. Now you have another 6-7 weeks until the opening of the next Congress, which is, the cleanest date when it can start. When do we start? When do we start the impeachment trial? So while, it might have the same practical effect, the long-term consequences and the legal consequences are serious and undermine not just impeachment as an accountability mechanism. It undermines the Senate's role as an cog, an important cog in the whole accountability mechanism in our constitutional government.
Okay, I want to circle back to what you said earlier that all these things that happened last night, they were not actually kumbaga, hindi siya talagang malinaw sa Constitution. It's not part of the process, but we also heard former Justice Adolfo Ascuna, who wrote Article 11, he actually sort of sees the kumbaga, common sense in all of this, right? And he explained himself. But if there is no real kumbaga, instructions on how we do it, there's also really no clear instructions on what not to do, right?
That's true.
And that's why everyone is arguing right now. So I suppose I just want to ask what the position of UP Laws is. Is the law school taking a position on this?
We haven't really met yet, even as a smaller faculty of constitutional law professors, to discuss this. But we were discussing a bit with some colleagues this morning when it happened. So a few things, right? I'll try to keep them as brief as possible. The first is, I don't think it's necessarily correct that the Constitution isn't clear on the point. It's clear at least on the point that this remand isn't in the Constitution, right? It's also not in the Senate rules. So the remand is not something that was available in the first place. On the second point, on Justice Ascuna's point, I think I understand the practical reasons he was stating. And of course, as a framer of the Constitution, he has a very important role in trying to help us understand it. But the primary way we understand the Constitution in Philippine interpretation is not the views of just one framer, not even the views of the entire chamber. It's what the text says, what the spirit of the text is, and what the larger context of the constitutional text is. How do we make the Constitution work as a whole? That brings me to my third point, which is emphasizing what the law faculty has said last week on how we try to understand these difficult provisions in the Constitution. A good guiding star would be, what would be a proper reading of the Constitution that would further accountability? And at least from our perspective, and I think the perspective of many other people who have been looking at this very closely, delaying the trial again, or effectively, and punting a difficult political question to another branch that has already done its job, right? We can say imperfectly, but still has done its job. That doesn't really further us in the accountability process. It doesn't make us closer to knowing what really happened, right? Or whether the accusations against Vice President Duterte are really true. So it doesn't move us closer to the constitutional principle of accountability.
Okay, so Attorney Will, one of the purposes of remanding the impeachment complaint to the House is for them to prove that they followed procedure, it was constitutional. But it's quite interesting because it's not like, are you expecting a different answer from House, right, to confess that they did not follow procedure? So by that, can you also share your opinion on whether the complaint really followed the 1-year rule? Did it violate it? And if not, is this just a deliberate delay on the part of the Senate?
So I'll say for now that I think I don't have enough facts with me, right, to understand really whether the 1-year bar rule was violated. There might be preliminary review. I don't want to soil the discussion that's happening between the two houses now by providing something that's not founded on facts that I actually know. But on that point, I think one thing that to highlight is that when the House passes a normal bill, let's say a bill for legislation, and moves it to the next, right, or to the Senate doesn't question whether enough people in the House voted for it. The Senate doesn't look into the records of the House and their journal on whether there was compliance with the constitutional procedure. It accepts it as a matter of respect for the other branch. And I don't understand how impeachment, which is subject to the same constitutional rules, right, why that rule of respect wouldn't apply here. And so it's certainly problematic because I think it also pits the House versus the Senate, which is not the intent of the constitutional system.
Eventually, Prof, this will end up in the Supreme Court. But we know that the Supreme Court is also very careful before it intervenes in matters like this. What would trigger, because there's several petitions now pending before it, what would trigger the Supreme Court to finally say, we intervene here?
I think in the times when the court has stepped in very difficult political questions, it does so when there's a clear constitutional crisis or a threat of a constitutional crisis. I will echo what Ted said and say that we're not there yet. I don't think we're there. These are difficult questions, certainly difficult and even unnecessary, but it's not always a reason for the court to step in. And let me explain that briefly. We don't want the court to step in because we don't want the court to be an escape device for accountability, not for the Vice President this time, but for the Senate and the House, whether they performed their job. It's very easy to blame another branch or a third branch to say that, oh, it was the Supreme Court that ordered us to continue, or it was the Supreme Court that ordered us to stop. But that's not how the design of the Constitution is. The design of the Constitution is that in impeachment contexts, the Senate is supreme in its field, the House is supreme in its tasks, and therefore they are accountable not just to the Constitution, they are accountable to the people themselves for performing that task correctly. So it's important to watch the events closely because there may be developments that will call for the intervention of the court, but I don't think given...
We're there yet.
Yeah, and it might not be the most practical avenue, even for those who want impeachment to push through.
Okay. Let's discuss this term, Attorney Tamase, sui generis. We've been throwing it around as if we understand the Latin meaning of it. But where are the limits? So when we say that each impeachment trial is different from all the other ones, meaning they all have their unique characteristics and, events surrounding the impeachment itself. In terms of sui generis, ano yung limit nun? Because it seems to be people can just say, oh, kasi sui generis, so we can do this.
Right. And sui generis should not be understood as a blanket permission to just do whatever, right? The main limit of sui generis is what the current laws provide. And the Constitution, again, provides for a clean process. House first, then Senate. No ping pong between the two branches. We do it sequentially, right? At the same time, the Senate provides for its own rules, and the rules don't provide for this ping pong. So the principal limit of sui generis is just, the text of these documents. The second limit would be how do we read it according to constitutional principles and accountability. And I don't think it really, this passing the buck, essentially, doesn't further that.
This remanding to the House, I'm sure you lawyers and in the academe were seeing what scenarios could happen. Was this even something, could this have been hatched earlier by some people? Is it something that comes out of your sleeve in a moment of wanting to compromise? I mean, we're entering the realm of speculation here, Prof, but may we have your thoughts?
I know, right? And I think that was, we can, let's assume, right, that the premise of that question is that they just decided this last night. If they did, it talks about the importance of looking at the consequences, of the longer term consequences, right, of each action that this impeachment court does. It has very long downstream effects, basically, on what the process will be moving forward. It also is important to consider how the public will react, because and not not particular parties or not particular partisans, but will it undermine the faith that the people have in general with the process and with the institutions running that process. And I think if they were trying to come up with a compromise, the cost of that, which is what we are suffering through now, might not have been worth it.
All right. Well, we thank you so much for sharing your thoughts and your analysis. Thank you so much, Professor, UP College of Law Assistant Professor Paolo Tamase.